Hello class, my name is Abdul-Abubakar. On the topic of HIPAA. What is HIPAA? Health Information Portability and Accountability Act. Regulates privacy, security, billing of healthcare information. Applied to most healthcare providers, health plans, and clearinghouses. Monitored by Office of the Civil Rights, the U.S. Department of Health and Human Services. What is HIPAA? HIPAA is a legislation adopted by Congress in 1996. The Health Insurance Portability and Accountability Act provides broad new protection for the privacy of medical information in order to protect medical privacy. The law established standards for the privacy, security, and electronic transmission of health information. The HIPAA privacy rule applies to the use and disclosure of patient health information where the identity of the patient could potentially be revealed. When did HIPAA become effective? HIPAA became effective April 14, 2003. Under HIPAA, when can healthcare provider use or disclose information without first obtaining specific authorization from the resident or patient? A healthcare provider may use and disclose protected health care information for treatment, payment, and operation without obtaining written authorization from the patient. What privacy right do resident or patient have under HIPAA? The right to receive a notice of privacy practice, the right to inspect and obtain a copy of their protected health information, the right to request amendment or correction of their protected health information, the right to receive an accounting of disclosure of their protected health information that were made to third parties for purposes other than treatment, payment, or healthcare operation. The right to request further restriction on uses of disclosure of their healthcare information. What is protected health information? Protected health information is any information in any form, oral, written, electronic, that a healthcare provider receives or creates that may be used to identify a resident, the resident's health, or the healthcare services the resident receives, whether in the past, present, or future. A written authorization must be obtained before releasing protected health information for the purpose other than treatment, payment, and operation. This is the law. In this case, The defendant failed to convince me that this was done. They just act based on the subpoena issued without informing the resident. So in this case, I would say I side with the plaintiff rather than the defendant. Source of information is from CFR, that is Title 11 of the CFR Part 50 and 60, that is the Federal Code of Regulations, and also from the Department of Human and Health, U.S. Health and Human Services, which is Title 45, Part 46. Thank you.